Good morning, everyone, and good afternoon, those of you who are out east. It is Human Rights Day, and I'm Leilani Farha with Canada Without Poverty, and this is our first webinar on the implementation of human rights in Canada. We obviously chose December 10th for a particular reason to host this webinar, and I would have to say it's not because of our impeccable record at this point in time on the realization of human rights in Canada. Quite the contrary. For us, December the 10th this year is a time for reflection. So before I proceed with a few comments, I just want to let you all know that there are about 40 of us who have joined together today to discuss the implementation of human rights in Canada. And I don't know if you all can somehow see a list of who else is participating, but I believe we have broad representation from across the country. So my reflections today, I wish I could come here and wish you all a happy International Human Rights Day. But I think we're at a point in our social, political, and economic history in this country where we can't do so. And I think in large part that's due to what's going on in the country right now as a result of the leadership. I had occasion this morning to think through, and yesterday evening, a little bit of, where are we right now in this country vis-a-vis human rights? And I reflect on the fact that on the day, the International Day for Human Rights, where we're all supposed to be grappling with human rights and thinking about the Universal Declaration, there's relative silence, and I think it's really loud from this government on this particular day. And by this government, I mean the federal government. So I don't see on any home pages of ministers, the Prime Minister, or the Minister of Justice, or the Minister for Human Resources and Skills Development. I don't see on their home pages a big celebration of human rights. In fact, I went to their home pages this morning and I actually saw absolutely nothing. So on this day, the silence from our government is really, really audible. And yet on other days, almost any other day of the year, this government is not so silent on human rights. It's really clear that they care about human rights. They care to dismantle human rights in this country, and they care to challenge and threaten those of us who do care about human rights. And I'll just give you some examples that come to mind. 29th of November, that auspicious day, John Baird, representing Canada, was one of only 9 states worldwide to vote against Palestine, becoming a non-member observer state at the UN. And then a few days later, Canada failed to protest Israel's reprisal of increasing illegal settlements in occupied territory. Let's take another date. Let me see. The 29th of June, the Omnibus Budget Bill is passed, which includes a sweeping attack on human rights, the defunding of the National Council on Welfare, the defunding of Aboriginal health research bodies, an increase to the age of eligibility for old age security from 65 to 67, and changes to employment insurance, penalizing unemployed workers in seasonal industries. What else? 24th of March, the Government of Canada prohibits failed refugee claimants and claimants from particular countries, as well as undocumented migrants, from receiving health care, effective June 30th. So when you look at, and those were just random dates throughout the year, not December the 10th, the government has been very loud about human rights and its disdain for human rights in this country. And I should of course mention, I think it was in May when the government came out swinging at the UN Special Rapporteur on the right to food, saying that Canada should not be under scrutiny and that the UN should spend its resources in developing countries or in other countries where food insecurity is a real issue. So it's with that bit of heaviness that I come to our discussion today on the implementation of human rights in Canada. I think this is an important discussion in light of what's being dismantled in this country and what's being challenged in this country by our leaders. So let me tell you, sorry, I've been given my time. I have 1 minute, which is perfect, because I want to spend the next minute telling you about this webinar and how it's going to work, who's going to speak, etc. So we are really privileged to have 3 speakers with us today, 3 panelists. We have Steve Estey, representing the Council of Canadians with Disabilities, Annabelle Webb, representing Justice for Girls, and Bruce Porter, representing the Social Rights Advocacy Centre. And all 3 of our panelists have incredible experience and expertise implementing human rights in Canada, using international human rights domestically in a variety of ways and with a variety of populations and constituencies. And I'm hoping through a sort of interactive discussion style format, we can learn from their experiences and their expertise. So the way it will work is I will pose questions to each of the panelists in turn, starting with Steve and moving to Annabelle and ending with Bruce. And hopefully it will be conversational. I do intend to interrupt, and I do intend to keep time. Each panelist discussion will last about 10 minutes, and then we want to open it up to questions. And there are 2 ways for participants to ask questions. You can send an email, and I'm not seeing it, there we go. You can send an email to Michelle, and her email address should appear before you on your computer screen. Or if you're a Twitterer, you can tweet, and the tweet is at CWP_CSP, and my colleague Megan will be handling the Twitter feed. So please feel free to ask questions, and you of course can ask your question, or send your question I should say, in the midst of the panel discussion, but we will reserve questions till the end of the panel discussion, which should last about 30 minutes. And that will leave us hopefully with 30 minutes of discussion time. Our panelist Steve Estey is using captioning, which means there will be some delay between your questions and Steve's responses, as they're going to be typed out for Steve to read. If anyone participating is hearing impaired, you can access the captioning by copying and pasting in the link that should be on your screen now into your web browser. You'll see there it says captioning. So you just paste that into your web browser, and you'll get the captioning. So I guess we're going to start right in with Steve. And I have questions for you, Steve, regarding obviously the Convention on the Rights of Persons with Disabilities. I would like you to talk a little bit about the importance of this convention, and more specifically about how the disability rights community is now mobilizing around the convention. You know, I know that Canada ratified that convention recently, so I'm interested to know what that means to those of you working in the disability rights community, and you know, the importance and significance of it to you.
I'd like to thank you for the invitation to be here with you today. It's an interesting technology. It's my first time using it. Talking about the CRPD and how the disability rights community is using it, Canada ratified the convention in March of 2010, and that obliged us as a country to file our initial report with the experts committee within 2 years. So it was due by March of 2012. Now, in fact, Canada has not yet submitted the report to the experts committee. It's just in process, and we understand that it will be released sometime in early 2013. We haven't seen the content of that report. We've been a little bit surprised by the process around it, because with the CRPD, there's an expectation that civil society would have been fairly extensively consulted in the development of the States Party report. That, however, hasn't happened. So the disability community is simply waiting to see what the report will look like before we begin to develop our strategy around shadow reporting and so on.
And Steve, can you tell me, did civil society try to engage the process of the writing of the report of the government's report?
Yes and no. What happened was the Department of Heritage issued a list of questions that were going to form the basis of the report, and they asked civil society to comment on those questions. We did that. It was just a web-based formula, and there was no exchange. They simply put out a call for comment on questions. We made comments, and that was it. we had expected, as I say, a much more robust consultation process around it, but that didn't happen. So we're just in a kind of wait-and-see situation now.
And when we talk about implementation of human rights, you know, I probably should have said at the beginning, my sense of the different forms of, you know, how we might implement human rights, make those international human rights real at the domestic level, and so that, you know, they're meaningful in the lives of the most disadvantaged people in Canada. I normally think about using courts and tribunals. I think about using the UN system. I think about using the parliamentary system. I'm just wondering, you know, do you see using the treaty, the CRPD, and the committee as central to the realization of economic and social and other human rights for people with disabilities? Or how are you viewing it, given that the government, from what you've said, hasn't really changed the way it's interacting with civil society with this treaty? It certainly has done the very same thing with all the other treaties that some of us have used and engaged with. I'm just wondering, you know, what kind of role do you see the committee playing and the UN system at this point?
The whole process around the committee is something that is new for the disability rights community. You know, we, as I say, ratified the convention 2 years ago, so this is really our first kick at the can, if you will, and we're just trying to get parameters organized and straightened out. But I personally see the work of the committee and the role of the committee as being tremendously important for us, because it gives us a body outside of Canada with which we can dialogue, talk about the implementation of the treaty and so on. So I think that from what we've seen with other states parties when they've gone before the committee, they've had very useful discussions with the CRPD committee, and those have led to some very helpful concluding observations. So what we're looking for at this point is a process which we can frame, which will lead to useful concluding observations a few years down the road. But that process is something, as I say, that is just kind of being developed, if you will, and something that I should note with this, and folks here probably are well aware of it, there's a lag time between the time of the submission of the States Party report and the time when the committee actually reviews that, and we're looking at probably 3 or 4 years before the committee actually gets to Canada's report. In the process along the way, there will be opportunities for engagement with the committee and with the committee to get them to develop a list of questions that the Government of Canada will have to respond to. Those questions, we're hoping, will be developed basically by what will be gaps between the official state party's report and the shadow report which civil society will develop between now and the time that the questions are developed, probably in 2 or 3 years' time.
Steve, can you tell me, and I'm interested in a couple of things. One, was there a difference between how Canada negotiated the Convention on the Rights of People with Disabilities back at the UN when it was just being formed and developed, and how they're dealing with it now that they've actually ratified it?
Yeah. For folks who don't know, I was involved with the drafting of the convention. I was actually the civil society advisor on the government delegation. Those negotiations took place between 2002 and 2006. And for those of you who don't remember, in early 2006, we had a change of government here in Canada. So during the negotiations around the convention from 2002 to 2006, there was a fairly robust participation on the part of civil society and quite good engagement between civil society and government as we moved to develop the convention. And you and others were involved in that from the human rights community, but the disability community itself was quite involved with it as well and interacted with government and so on. Since the end of the negotiations, things have changed a fair amount in terms of the the engagement and collaboration between civil society and government. Part of that process is a natural one, I think, in terms of government needing to do the work of ensuring that its policies and laws are in sync with the convention to move toward ratification and so on. But as I mentioned earlier, we had expected that once we ratified, there would be a sort of re-emergence of this collaboration between civil society and government, and that really hasn't happened. The convention itself calls for a lot of collaboration between civil society and government. But the other thing, interestingly, that it does is it calls for a very particular role for human rights commissions, or they're identified as independent mechanisms in the convention in Article 33. And there's an expectation that when a country ratifies the convention, they will designate an independent mechanism to monitor the convention and its implementation at a domestic level. That didn't happen here in Canada. We had expected that the Canadian Human Rights Commission would be identified as the independent mechanism. The government chose not to do that, chose to be silent on it, and it's left us in a bit of a quandary. And I think it's left the Human Rights Commission in a bit of a quandary too about how to proceed with that. So yeah, I get the answer. The one-word answer to your question is there a difference between then and now? The answer is yes, definitely.
Thanks, Steve.
Okay.
So I wanted to ask you, Annabelle, I know that Justice for Girls has used the international human rights system extensively to ensure the rights of girls are realized back here in Canada. I know for a fact, because I've worked with you on some of this stuff, that you've used the Committee on Economic, Social and Cultural Rights, you used the Women's Committee, you used the Children's Committee, and you engaged in the Universal Periodic Review process. And some of those things you may have done more than once, actually. So I'm wondering if you could provide us with a background on why you chose to use the international system in your work, and what your assessment is of your achievements to date, or your failings, or the failings of the system.
Sure. Well, our engagement with international human rights started back in 2003 when we were invited as part of a coalition of women's organizations, actually, a group called the BCC Coalition, because they were making a submission to the Committee on the Elimination of Discrimination Against Women, and we were invited to be part of that coalition. And so it was brand new to us, and we liked the idea of trying to frame our work in terms of international human rights, partly because at the time we had a conservative provincial government, we had a conservative federal government, and all of our efforts domestically seemed to be hitting brick walls. And so we liked the idea of going outside of the domestic context to try and find rights of teenage girls living in poverty. And so our initial engagement was through the CEDAW committee and as part of a coalition, and from there we, as you say, we've made submissions to various committees and through the Universal Periodic Review, and also to the UN Special Rapporteur on Adequate Housing. And for us, the reasons for doing that, as I say, have been partly about hitting walls domestically, and partly about trying to frame our work more broadly in a global context of human rights, and connecting with activists who are doing human rights work across a variety of contexts domestically. So it was our belief that if we were able to get the United Nations to make comment on particular human rights failings, that we could then use their comments and their observations to bring it home and use their findings as advocacy tools in the domestic context. And so that's what we've done. It's been a really amazing journey, actually, in terms of our learning. And also, I think we've had some successes in using the international human rights bodies to push for our advocacy interests on behalf of teenage girls who live in poverty.
Annabelle, can you tell us a little bit about those successes and the interplay between, let's say, getting good comments or concluding observations from the UN system as a whole and your domestic advocacy? How are you using what you're doing at the UN in BC?
Sure. One thing I should say is that in the advocacy that we've done and in preparing submissions for the United Nations, various bodies, we've been particularly strategic about which points of advocacy that we want to hit. So part of what I should say is that our preparations for any submission that we've made to human rights bodies has put us into a position of having to really research what Canada's position on certain human rights issues are and where the gaps are and where the failings and where the misrepresentations are. So it's been a really useful exercise for us as an organization to really see how Canada is misrepresenting human rights failings in Canada. So that's just one thing that I think is very useful for any organization to do, is to sit down and look at, again, part of our preparation is looking at what the United Nations has said in the past about Canada on particular issues and looking at that conversation. So that's been really useful, just to see how Canada represents itself outside of our context, and also to realize that many people, have this belief that Canada is such a great upholder of human rights, and when you step into the international context and see that there's actually a great deal of frustration with Canada amongst various human rights bodies, that the reality of Canada's record is quite different from the sort of self-righteous image that Canada has, that I think was really based in a period maybe back in the 70s and is no longer the case, as you pointed out. But so for us, doing that research is really useful to walk through the social policy and then bringing it home. Anywhere we've got any comment by the UN or any recognition of the specific rights of teenage girls in poverty, we've quoted anywhere and everywhere we can what the UN has said or called for in relation to girls' human rights. So, and on multiple levels. So, for instance, in conversations with the Special Rapporteur on adequate housing, when he specifically acknowledged that girls were specifically vulnerable in terms of homelessness and often driven into homelessness through domestic sexual abuse, we then would use that finding to present that to other UN human rights bodies. And then when they have acknowledged specifically girls' vulnerability in the situation of homelessness, then we would bring that home and put it to domestic policymakers. So if we're trying to get a change in the provincial government, we would quote anywhere and everywhere we can. Advocacy letters, we will pull out those recommendations on specific issues. And the other way that we've brought home the work that we've done internationally is when we're working with other advocates. And I think of one example in a place where the advocates were very isolated and very marginalized, who were trying to do work around violence against girls and poverty and the impacts of colonization in the north. So when we went to do some advocacy training, we're bringing the global context of human rights home as kind of a reassurance that we're not alone in this work, and there are some very clear standards internationally that are not, we often get framed as extreme and radical and pushing, and when we bring these things to the ground and remind ourselves that there's a global consensus on many of these, there's a solid framework of human rights standards that are really quite basic and that we all should feel very much entitled to advocate for. Domestically, it's been really helpful to feel like we're not alone in this work that we're doing, and these are basic standards that the rest of the world agrees upon and we should feel most entitled to push for them. So those are some of the ways that we've brought the work home. We certainly, in talking to young women about their particular situations, make it very clear to them that they should feel entitled to a variety of human rights, and we will walk them through. You know, this is what the United Nations has said. These are the, and I think it's quite reassuring to everybody to know especially when human rights are under attack, as you rightly pointed out, Leilani.
And just one final question, Annabelle. I'm interested to know how human rights, as articulated by the UN, have been received by provincial politicians you've met with and by young women or girls that you're working with. With the girls are really, I just think of a couple of girls, for instance, who we took actually to be at the recent review of Canada on the Convention on the Rights of the Child, and we did an internship with the girls to teach them about how the Convention on the Rights of the Child applied in terms of the specific issue of climate change, and also looking at the gendering of the Convention on the Rights of the Child. And the girls absolutely embraced the rights in that convention, had no trouble understanding or applying them, grabbed a hold of them, and made really amazing arguments about how, for instance, in the case of climate change, how climate change is an urgent human rights matter for children. And it was amazing to watch them move through that document and just pull out the rights and very effectively apply them to the issue of climate change and also violence against girls and other issues of poverty. But so, you know, and certainly that's the case when we talk with other girls. I think it gives them a bit more of a sense of entitlement to push for what they believe in, and sometimes it just validates what they know to be true and have always known to be true, but it kind of adds a framework. So, you know, I think that's, with the girls, it's an immediate embracing of a set of standards, a set of rights. In terms of policymakers, or, you know, we often build on these things. We kind of build a foundation from you know, going to a Senate committee, which we then take to a legislature. You know, we're kind of building, we're pointing out that here's a concluding observation, now we're going to put that to a Senate committee, now we're going to take that to, you know, certain legislators. So I think the work is not just simply, you know, I mean, it is, there are times where we've just simply quoted the concluding observations when we're trying to advocate for policy change, for instance, within the prisons for girls, you know, where they're, we'll just quote something that a committee has said about recognizing, for instance, that co-ed incarceration of girls with prisoners is a violation of girls' human rights. So it really depends, but I think that is a building sort of piece of work where we have a foundation and we're going to keep, you know, just layering it. You know, some, I think, absolutely, the federal government clearly has a complete disregard for the observations of the United Nations, and were quite clear that they were not overly receptive. On the Committee on the Rights of the Child recently, they pointed out that their response was that there was a member from Syria on the committee, and therefore they didn't need to listen to the Committee on the Rights of the Child, which was absolutely offensive, and I think a clear indicator of their disregard or disdain for the United Nations at this point. So, you know, it varies, depends which policymakers or lawmakers we're dealing with. Thank you, Annabelle.
Started off by saying Happy International Human Rights Day.
Ah, he's claiming it. I still don't feel that I can say Happy International Human Rights Day, but maybe with all of us.
I take it, Leilani, as a recognition that the current government doesn't define human rights for us. We're celebrating the Universal Declaration, being 64 years old, and there are other things to celebrate. There's an optional protocol that is now 4 years old and on the verge of coming into force that allows us to claim and enforce economic and social rights internationally. So, I think the question is, how do we bring Canada on stream to a lot of things that really continue to be very positive?
Yes, I take your point. And in fact, that's kind of where I wanted my questions to you to go. Because you've been obviously doing economic and social rights in this country for a fairly long time. And you've seen lots of ups and lots of downs. And I think lots of downs right now. And yet, I know in your work, because I've worked closely with you, that you always take a creative approach to implementation, and you continue to be optimistic that we can find ways to implement economic and social rights in Canada, even in the harshest of climates. So I wanted you to speak a little bit about some of that work that you've done. In particular, I'm hoping you'll speak to a piece of legislation that you've been heavily involved in, Bill C-400, and I'm hoping you'll speak to some of the litigation charter challenges you've been engaged in. And I'll let you decide which you take first, the political or the court cases, although of course the court cases are political.
Yeah, well, thanks. So, starting just with the court issues, I mean, we've had some losses in courts and we've had some victories, and I won't go through all of those, but I will say that it's important to know that the door is still open on the possibility of claiming most of Canada's international human rights obligations as rights within Canada. The basic rule is that our domestic law is supposed to conform with our international human rights obligations, and so there shouldn't be anything in the Convention on the Rights of Persons with Disabilities which recognizes that people with disabilities have a right to adequate housing and the right to work and other social and economic rights. Canada has undertaken to respect and comply with that international human rights law, which means more than just policy commitments. It means that we have to provide effective remedies in our own law for violations of those rights. And so people with disabilities now ought to have a place where they can go and claim and enforce the right to work or the right to an adequate standard of living. And if Canada isn't providing us with that, then we can work to ensure that that is better done. That we can say you're not in compliance with your international human rights obligations if you're not giving us a place to claim and enforce these rights. And the same applies to the interpretation of rights in the Canadian Charter of Rights and Freedoms. The right to security of the person, clearly, to most of us, would suggest that we need some basic housing in order to enjoy security of the person. And the right to life means to health and access to utilities so that we can keep warm. All these basic common sense things are things that our courts have not really engaged with. There haven't been clear decisions. But it's still an open question, and it's something that we have to continue to fight for, is an understanding of our rights and of our human rights legislation, which is consistent with our international human rights obligations. So that's why, as Annabelle was saying, it's always been so interesting for us to go to these international bodies and find that far from Canada being seen as this great respecter of human rights, the idea that the Canadian government would have about human rights and international human rights is that this would give us the opportunity to tell the rest of the world how to comply with human rights, to sort of, send our judges around and they can tell everybody about how great the court system is in Canada. But that's actually not our experience internationally. Internationally, the idea is that every country has to comply with the rights, and in the area of social and economic rights, we have to comply with them and implement them to the extent that is possible with our resources. And so, far from people being apathetic or complacent about the problems of homelessness or hunger in Canada because they're not as severe as in some of the impoverished countries in Africa, that's the line that our government took when the Special Rapporteur came. The concern internationally is that if Canada, with all of its wealth of resources and its history of commitment to human rights, can't address these problems within a human rights framework, then who can? And our obligation is to do our best, to do what we can, given our court system, given our resources, given the history we have. It takes you from where you are to someplace where you want to be. And so that's why on International Rights Day, I think of it as a possibility of re-engaging with these values that we've always held dear and which have been eroded. But there's no government that can decide that Canada doesn't respect the Universal Declaration anymore. There's no government that can tell me that the right to adequate housing isn't a right anymore. These are rights They've been entrenched in international human rights law. And when there's a growing gap and disparity between what people are recognizing internationally and what our governments are doing or recognizing domestically, that's when we have to start to take these international, demand that they be implemented in meaningful ways in Canada. So, you know, quickly, the ways in which we've been working on doing that, Bill C-400 you mentioned is a housing strategy bill, which builds into the obligation that governments have to implement an effective strategy to address homelessness and ensure the right to adequate housing. That's an obligation under international human rights laws. UN bodies have been urging Canada for years, saying, why are you one of the only countries without a housing strategy? Implement a housing strategy, but base it on the right to adequate housing. Make it a rights-based strategy. What that means is there's a complaints mechanism, there's independent monitoring, there's engagement with human rights institutions, so that you actually say, this is a human rights violation that has to be remedied. We can't remedy it right away in every way possible, but over a reasonable period of time, provincial, federal, municipal governments have to take this on as a human rights issue and solve it. And so that bill provides a mechanism through which a conference would be held and governments would then develop a strategy based on the right to adequate housing, and with the realistic obligation and expectation that within maybe 10 years we would no longer have homelessness in so affluent a country as Canada. And at the same time, you know, we're going to court in a case where we're demanding that if governments continue to refuse to implement an effective housing strategy like this, then they're in violation of people's rights to security of the person and to equality. And so we're saying, if you're not going to respond to a piece of legislation that is before you that you can support and which would implement international human rights obligations, then it's the role of the courts in Canada to ensure that people have this kind of strategy. You can't allow people to continue to become sick and die on streets and suffer all of the consequences of homelessness, clearly a violation of the right to security of the person. In those situations, just like if people are being forcibly evicted in a developing country, it's up to the courts to step in and say, sorry, governments, you're not doing your job, and you need to come back and tell us what you're going to do to ensure that these people have access to adequate housing. So we're asking that Canadian governments be held to account by courts, but that's not the only place. You know, we need to build this idea of fundamental human rights into all of our decision making. So, you know, why are we setting social assistance rates at so low a level that people aren't able to access adequate housing with the amount that they get? Why are we allowing people with disabilities, mental health disabilities, to be so overrepresented among people who are homeless because their needs aren't being met? So these kinds of questions have to be put to our governments within a human rights framework, and then there has to be this human rights framework created for people who are making decisions. So no longer would we decide on the level of social assistance without saying, oh, I guess housing is a fundamental right. Maybe we should set social assistance rates at a realistic level so people could access adequate housing. And maybe we should ensure that when institutions are closed, that there is adequate supportive housing available and supports necessary for people with mental health disabilities to ensure that they're not left without any adequate housing. So these kinds of norms have to be built into the way we decide all of our policies. And that's what a human rights framework does. It says these are fundamental. These have to inform all of our decisions. It's not that radical a claim. You know? These are the values that, and what we have now in our charter jurisprudence in the cases that have been decided before courts is an understanding that any reasonable decision really should be taking into consideration the fact that no one should be homeless in Canada, that this is a human right. And there are bases now for us to go to housing tribunals and administrative decision makers who administer social assistance and say, sorry, but if you're making a decision without thinking about my fundamental rights, that's not a reasonable decision. So there's lots to work with. We just have to claim it in all over the place, in a variety of places. You know, get city charters and get housing strategies and anti-poverty strategies, and demand that the way that we structure legislation starts by saying that these are fundamental rights.
So I guess my question to you next then, and I obviously, I've been involved in some of the work that you've just referred to, and I do see those as possible sites. Sort of, it's like, there, in a way it seems to me you're suggesting that there are everyday sites where we could be trying to get human rights values infused in everyday decision making, in our everyday work. That we don't have to all tromp off to the UN or to courts
and expensive legal systems to do this stuff in our work, that we could be doing it, as I said, in our everyday work. I guess one question I do have on the structural side, though, is do you think we need any new mechanisms in Canada for, for the implementation of human rights? You spoke of Bill C-400, which calls for particular mechanisms, a review mechanism and a monitoring mechanism vis-a-vis housing and homelessness. But do you think there should be some kind of overarching mechanism available for the implementation of human rights or economic and social rights more specifically in Canada? Like I'm thinking, you know, I've heard people talk about parliamentary mechanisms or some kind of an ombudsperson. Let me see, I don't know, have we gone offline? There we go, we're back. So I don't know if you have any comments on those, Bruce.
No, I think it's critical that we have, you know, it's sometimes referred to as framework legislation or implementing legislation. Canada is what's called a dualist country in the sense that when we ratify international human rights treaties, they don't automatically become part of our domestic law. And we don't have a tradition, and we're not advocating, those of us who work in the area of human rights in Canada, we're not generally saying that Canada should incorporate directly all of the treaties that it has ratified and make them enforceable domestically. We have more of a tradition in Canada of saying, well, okay, we'll have our own Charter of Rights and Freedoms, we'll have our own human rights legislation. What's critical is that the courts and tribunals and decision makers interpret that domestic law consistently. So there's actually a healthy kind of dialectical relationship where international law speaks to Canadian law and Canadian law speaks to international law. But that has to be made real. And what's happened in the last 10 or 20 years is that Canada has insisted that these recommendations that come out of UN committees, oh, these are just, you know, recommendations. We'll read them and then we don't do anything with them. And that's not a good faith relationship with the United Nations treaty monitoring bodies. These should be treated as seriously as domestic court decisions. These are very important insights, reflections on where Canada is. And so when the highest level UN body says that homelessness is becoming a human rights crisis in Canada and needs to be addressed as a human rights crisis, then there has to be some mechanism through which this is automatically looked at, considered, in the same way that a court decision in Canada would precipitate some kind of action by government. So, you know, I think what a lot of us are looking at now is the idea of some kind of framework legislation that says, okay, when a UN treaty body makes recommendations, what happens to those? We need parliamentary committees and legislative committees. It has to be dealt with both provincially and federally and often municipally. So every level of government should be responding. And there needs to be an obligation on governments to take those recommendations and to hold hearings, to consider what's going to be done with them, and then to act on them. And that could be clarified in framework legislation, both federally and provincially.
Thank you, Bruce. I think we're going to move into questions now. We have how much time? Sorry, I'm just asking we're just checking. Because the conference started a little bit late. I mean, the webinar started a little bit late. And we were only booked until 1 o'clock, which by my time leaves us with 2 minutes. I'm going to ask people to send in questions if they haven't already. Have people been sending in questions yet? Not yet. Sorry, we can?
You can go ahead.
And we have some liberty, I think maybe 10 minutes or 15 minutes liberty. So I'm going to move into questions, and you'll forgive me, but we have I have to leave for a second to get the question, I think. So we have a question coming from Montreal. Okay, so under the new Quebec budget, or a recent Quebec budget, there was a $51 million cut from social aid programs and $56 million from social housing cut. And so the question is, how does one address this using human rights or a human rights framework? And so, I don't know, Bruce, if you want to start. I don't know if we still have Steve and Annabelle. I don't have video for either of them. So, Bruce, maybe you're on in the hot seat at the moment.
Okay, well, this is an issue that is being dealt with in many countries as as people will know, the way in which austerity measures are adversely affecting those who are most disadvantaged, those who need social housing or social assistance, would clearly be most impacted by the cuts that are being described. And there is an obligation under international law to attend most seriously to the issues that affect the most disadvantaged groups. So any kind of cut that is affecting people with disabilities or Indigenous people or people who are at risk of homelessness, those kinds of cuts would be subject to the most serious scrutiny. There's a concept in international law called retrogressive measures, or deliberately retrogressive measures. And so if the government of Quebec has implemented these changes, knowing that they will have the effect of violating the rights of particular groups, and that they aren't absolutely necessary, then that would be a violation of international human rights law. The Quebec government tends to take international human rights monitoring more seriously than other governments in Canada. It's certainly something that's worth raising in different contexts. The most immediate opportunity will be in the Universal Periodic Review, which we haven't talked about, but which is scheduled for April 26th, I believe. And these kinds of issues are going to be reviewed in the Universal Periodic Review, where Canada is being reviewed for compliance with all of its human rights obligations. And clearly there will be an understanding that as a federal country, a lot of the issues fall within provincial jurisdiction, and so if there are concerns about what the Quebec government is doing, those could be put before the UN Human Rights Council and addressed to the delegation for the Canadian and provincial governments in Geneva during the Universal Periodic Review. I believe there will be a representative of the Quebec government attending Canada's Universal Periodic Review to answer questions about Quebec, and that would be an opportunity to raise that issue.
Thanks, Bruce. Steve or Annabelle, do either of you want to weigh in on what can be done from a human rights perspective to address the social cuts that are happening in Quebec? And can I just verify that Annabelle and Steve, you are there? I cannot so verify. All right, I'm going to, are there other questions?
I'm here, Leilani.
Oh, great.
Well,
sorry, I thought about the delay. And Steve, did you want to weigh in on the question that was just posed? Maybe I'll put back to Steve now that I know that you're online. My original question, I'm not sure that I can completely paraphrase it, but I had a question because I don't think we have questions coming in through Twitter or email yet. My question to you, Steve, specifically was around this Article 33 and the implementation mechanism proposed therein, something along the lines of a National Human Rights Commission acting as some kind of a mechanism for implementation of the CRPD domestically. And you said that hasn't happened. We know it hasn't happened. I'm wondering if you can update us on where you think that's going, and also whether you think that's a good idea, whether the Canadian Human Rights Commission has the capacity to act as an implementer or monitor of some sort, a review mechanism, and not just for the CRPD. I mean, I'm interested in it as well from the points of view of other treaties. So I don't know if you would be willing to share some comments on that.
I'm not sure whether we're connected, Leilani. Can you hear me?
Yes, we are, Steve. I can hear you now. Yes.
Oh, okay. I think that it's important to note that the CRPD is different than other international human rights treaties. It specifically talks about a role for domestic monitoring and implementation. This Article 33 that you referenced is distinct from other human rights treaties. During the negotiations, there was a lot of talk about how we could make the implementation of the treaty more effective at domestic level, and the Article 33 is the effort of the drafters to make that a reality. So we talked about it, and during the negotiations, there was a strong presence for international or national human rights institutions who argued that they had a role in domestic implementation. But if you look around the world, less than half of the countries in the world actually have national human rights institutions. So they use the term independent mechanisms instead, thinking that where there did exist national human rights institutions, those would be the independent mechanisms, and then in countries where they didn't exist, other mechanisms would have to be established. Now in Canada, as I say, we had anticipated that the Canadian Human Rights Commission would be designated. There was a lot of discussion during the time up to ratification about whether the Canadian Human Rights Commission was the ideal mechanism. The sort of question that you're talking about: does the Commission have the capacity to do what it set out to be, or what ought to be done under Article 33? And the consensus in the Canadian disability community was that while we didn't think that the Canadian Human Rights Commission was necessarily the perfect mechanism for this to happen, we thought that it was probably the best one that we were going to get. We didn't expect, were concerned that if the Canadian Human Rights Commission wasn't designated, nothing would happen and there would be no separate mechanism set up. So we have tried to support the Human Rights Commission in this process, but as we say, it hasn't happened. And after the ratification and the failure to designate, the Chief Commissioner wrote the Department or the Minister of Justice and asked specifically whether he would designate the Canadian Human Rights Commission. The Minister of Justice recently wrote back and said that it would not do so, felt that the Human Rights Commission was already in a position to do this and didn't need a specific mandate. So that's where we have it right now, and I think that the Human Rights Commission is really trying to figure out what the way forward is on this. Parts of this process also relate to the fact that we have in this country also in most other jurisdictions, provincial jurisdictions, human rights commissions, and those provincial human rights commissions are also trying to figure out what their role is in terms of monitoring the convention and so on. So, for example, I was at a meeting here in Halifax the other day at the law school with the Nova Scotia Human Rights Commission and some people that how these laws talking about what the role of the Nova Scotia Human Rights Commission would be in terms of monitoring and implementation of the convention here in Nova Scotia.
That's interesting. Thanks for that. Do we have questions coming in?
No questions.
No questions yet. I have another one, and then maybe we should wrap it up. I have one final question. In light of the government's attack on the UN system as a body sort of writ large, and in light of the only narrow opportunities, I would say, and I can be challenged, the narrow opportunities available through courts, particularly for the realization of economic and social rights. And given that we have a majority conservative government that is not interested in introducing legislation that would move forward an economic and social rights agenda or a human rights agenda writ large, I'm wondering if the three panelists might speak to what the heck we should do in this context. You know, I don't know how can we see who wants to go in what order. Maybe I'll go from Annabelle to Bruce to Steve to see if any of you have comments. I'm not sure Annabelle's still on the line. So I'm gonna move back to Steve. Steve, if you would have thoughts on what the heck we should do in light of the context that I outlined rather negatively, that would be great.
I thought Bruce was next, Leilani.
Oh, is that right? That would be typical me.
Oh, seriously, I mean, I don't know. Part of what we're doing in the disability community and trying to get our head around the way forward with this is we're looking to our provincial jurisdictions and working with provincial government, because I think you're quite right. It's very challenging at the federal level, but we are seeing at provincial level some recognition with it, the CRPD, for example, that it has an impact. A very interesting announcement came out last week from the government of Manitoba on this. They said that specifically in response to their obligations under the CRPD, they're implementing legislation that will eliminate the loophole in their provincial law that allows for sheltered workshops to pay people less than the minimum wage, which is an absolutely huge victory on the part of the disability community happening at the provincial level in Manitoba. We're looking here in Nova Scotia at using the CRPD around housing rights. And I was at a meeting with the Minister of Community Services here the other day. We talked specifically about housing and obligations under the convention and so on. So we haven't really moved to a point where we're using the courts and the disability community with the CRPD yet. It's early days, but right now we're focusing a lot of work at the provincial level.
Thanks, Steve. That's very interesting. And Bruce, I'll give you the last word on this.
I think we tend to learn in these times from our colleagues that have worked in hostile human rights environments elsewhere. And, generally the strategy has to be to use whatever you can to keep the values and the ideas of human rights alive and thriving, even if it's in little corners and pockets and so on. And there are all sorts of opportunities in Canada to do that, I think. And there's such a strong commitment to human rights in Canada at the grassroots level that I think we have lots to work with. So, even at the federal level, there are opposition parties, and they don't always frame these issues as human rights violations. And so there's lots of work that we can do with opposition parties. And I continue to think that even with Bill C-400 and a right to adequate housing, there was a motion on the right to adequate housing. It was put forward by Mr. Régent from the NDP, but he got unanimous support for it in May, saying that Canada should do more to respect, protect, and fulfill the right to adequate housing as it's required under the International Covenant on Economic, Social, and Cultural Rights. And Régent has had personal experience with homelessness and having to use food banks and trying to care for his children in those kinds of circumstances. And so he was able to talk more on a human level to some of the members of the Conservative caucus, and somehow managed to get unanimous support for that motion. So, and we see at the municipal level in places like Calgary, you have engagement by a wide range of people that might be supporters of the Conservative government, also believing that something should be done about homelessness and so on. So these are values which I think we can continue to pitch as universal. These aren't values that the Canadian government has thankfully not decided that we're going to withdraw from these treaties. They haven't said that we no longer believe that adequate housing and access to food and so on is a human right. They just try to deny us ways of claiming that right and making it real. And so we have to find ways to make it real so that people understand what it really means. We can do that by getting municipal charters that recognize human rights. We can do it by working with our provincial governments, as Steve has said. Many of the most important issues are addressed provincially, and there's very little engagement by provincial and territorial levels of government at this point in international human rights. So that could be changed by, getting new human rights legislation provincially that includes all of the international human rights obligations and getting more engagement from human rights commissions. So, I think there's lots to do, and there's no reason to feel too discouraged, because I think one of the things that we end up learning when they start taking away our rights is how important they were to us, and they are.
I think that's a great way to end, and I will just end by, first of all, thanking the three panelists for sharing their expertise and time with us, Annabelle, Steve, and Bruce. And I want to give a huge and special thanks to Ottawa University, the Human Rights Research and Education Centre, who actually made the webinar possible. And thanks to all the participants who are out there. Anyway, happy International Human Rights Day. Thanks.